Welcome to the Grow Your Business and Grow Your Wealth podcast with Gary Heldt. Gary is an expert in helping business owners put together a plan that will provide a better future for their businesses, themselves, and their families. On the podcast, Gary interviews other professionals who share his vision, and together they share secrets and strategies any business owner can use to build a better financial foundation for your business and your life.
Hey, welcome back to the podcast. This week, my guest is Gary Martoccio, and he is an employment law attorney and founder of Martoccio Firm, and they exclusively represent employees in legal disputes against their employers. Welcome, Gary.
Hey, thanks for having me. Gary and Gary show today.
Yeah. Our people that watch this show and everything are business owners. And you're usually, against the business owners. But I'm going to kind of flip this a little bit because so many small businesses don't have the finances to be able to have HR here in-house and stuff. Excuse me. And lots of times the office manager or whoever ends up by default being in charge of HR. So we're going to kind of flip it around that way. You have recovered a lot of money for employees over the years. What are some of the common things that have happened that allowed you to be able to recover that money for them?
Right. I think if an employer is not applying their policies equally across the board, I think that's one thing to always be mindful of. Another thing is documentation. So on both sides, you can see cases have pitfalls, whether my client, the employee, isn't documenting themselves well, whether they're asking for time off due to medical issues or maternity leave or whatnot, or the employer. If the employer has an issue with someone, it's better for the employee bringing the claim if they're not documented, they're not writing them up, sending an email, raising concerns, because you don't want the first time that you're putting anything in writing as far as concerns about performance or attendance to be on the termination, right? Because then that looks a little suspect. Then someone can say, well, you have not informed me, disciplined me. And it's not by law, you don't have to write people up unless maybe there's a union or, a public entity has some kind of bylaws, but otherwise, as a private employer, you're not required by law to do this, but it makes it that much harder to defend a potential claim if you're not well documented. So that's one pitfall that I see employers have, especially small employers, and just knowing the laws, right? Knowing what laws apply to them, what laws don't apply. The federal anti-discrimination statutes apply when you have 15 or more employees. Many states have lower thresholds, some as low as one employee. Some local governments have lower thresholds than the state. So if you're, if you're more than just a couple folks, I would be mindful. I would act as if you have 15 and that all the laws apply to you out there, the anti-discrimination statutes. When an employer hits 50 employees, that's a big one. And this is where a lot of employers may make mistakes around what's called the FMLA, the Family and Medical Leave Act. So if an employer has 50 employees and the employee in question has been there 1 year or more with the employer and has worked a requisite number of hours, it's 1,250 hours, so not a lot. So basically, if you're a full-time employee that's been there a year or more and the employer has 50 or more employees, you have to grant that employee 12 weeks of medical leave, whether it be for their own condition, spouse's condition, child's condition, or parent's condition. So there's a bunch of different buckets there that apply to it, or for maternity or paternity leave issues. So basically, you've got to give them 12 weeks of unpaid leave. And we see a lot of smaller employers that maybe are just hitting that threshold and not aware of the law and the ins and outs of it. We see that get botched quite a bit. And that's something, it's a little tricky. I would say once you get up around 50 employees, that means you're doing fairly well as a company, right? You probably want to have some kind of HR or employer defense expert take a look and make sure your policies are clear and that you're straight on the law. And I don't think it's something that you need, to do like tens of thousands of dollars into, just check in, make sure you've got it right, make sure you know when the FMLA applies, how it applies, and how to administer it. And those are the main buckets, I'd say. And then finally, I'd conclude with I see a lot of smaller employers have issues when an employee raises concerns, whether it be about sexual harassment or discrimination. You're required then at that point to conduct an investigation, to look into the concerns, take remedial action when necessary. So don't just brush people's concerns aside. You have a duty to look into them. And again, it's going to depend the size of the employer, whether those federal statutes apply or not. But I would still operate as if they do, regardless. And definitely look into an employee's concerns if they bring them, and definitely do the best you can to mitigate the situation if there is a genuine concern that was brought. So yeah, that's the gist of it. Those are the buckets where I see pitfalls on small employer sides, or any employer in general, but especially small ones. So yeah, I hope that covered a good amount.
Yeah, so lots of times, as business owners, again, going back, that when they're first starting out, they don't have the money necessarily to be able to talk to an HR specialist about getting their handbook set up, their employment letters, and all of that kind of stuff. How do you see it best for people to handle that? Because lots of times, if you don't have those employment letters, you don't have that. Lots of times, one employee may be treated differently than another employee.
Right, right. Yeah, I mean, it's obviously best to have policies in place, as far as if if an employee has concerns, where to bring them. If an employee has medical issues, where to raise, a medical leave request and whatnot. A progressive discipline process. It's good to have that in place. But I would say at the end of the day, if you don't have either the time or resources to put together some kind of formal handbook or policies, just be fair across the board. I've seen some really large companies where they don't even want to get into that, because a lot of times the folks on my end can start picking apart policies and handbooks.
Right.
Oh, well, you have all this and you didn't do this with my clients, and this process wasn't followed. So some employers, actually, even larger ones, just nix that whole thing and just say, our one policy is be fair, or be polite, or follow, I'm just thinking of a generic employer name. Follow the Smith's Hardware way, right? And that, I think, does solve some problems, honestly, and especially if you're being fair across the board. Though you don't want to discipline someone for one thing and not discipline another person. You don't want to have different standards for other employees, versus goals and quotas. You want to be as fair as possible. I think when you do that, I think people feel that too.
Right.
The employees themselves feel that, because a lot of the employees that come to me, they know they weren't treated fair or, equally than others. And, usually someone on my end can find a claim if that's the case. So try to just be as fair and reasonable across the board. And yeah, if you don't have time for some elaborate handbook or policies, just say, hey, we have one rule. It's to be fair and courteous to each other. And that's how we'll treat our employees, and vice versa.
How have you seen things change with so many people working remotely? How have you seen things change?
Yeah, it's definitely, different. There's a lot of stuff involving right now, at least, the Americans with Disabilities Act, the ADA, accommodations, where employers are now asking employees that come back to work that have been working successfully for the last 5 years. And now they're saying, well, you need to come back in. And that person may say, well, hey, I have this medical condition where I need to stay home, or I can't commute, or my child has this condition, or I'm pregnant, or I'm breast pumping and I need to stay home. Right. So that's the battle we're seeing now, because it used to be, an employer probably was okay denying remote work as an accommodation. But now it doesn't create the hardship on employers that it used to, because of Zoom and other platforms and other, remote work software and whatnot. So I think it's been kind of proven over the last 5 years. It's not really creating a hardship on the business, and this person can perform the essential functions of their job, which are the standards the law looks at. So we're seeing a lot of disputes and conflict there. I would say for smaller employers, if they have employees remote, one thing to be mindful of would be you need to follow the laws of both where you're from as the employer and where that person sits if they're in a different state. So that's something to be mindful of, and I've seen some missteps with smaller employers there. You want to be compliant and mindful, and there may be certain states where you have to register or like a workers' compensation law or whatnot. I'm not a workers' comp attorney, but just thinking out loud of some compliance issues that smaller employers may run into. But yeah, those are the things I'd see. With wages and things. If you have an employee in California, they have totally different laws, right? So you want to be mindful that not only the laws where you're based out of apply as the employer, but where that employee sits as well.
Yeah. And unfortunately, ignorance isn't a good defense against a lot of
Correct.
these things.
Correct.
Um, for small business owners that are just starting to hire people, what are some of the basic laws or places for them to go, would you suggest, to be able to look to find out, both federal and state statutes that they have to abide by?
Yeah, I'd be careful on with the AI platforms. I would right now,
Oh,
especially with
yeah.
legal stuff. Yeah, there's a lot of good that comes out of it, absolutely. And we use automation tools ourselves with drafting documents and things of that nature. But as far as legal research, I'd be careful. I would be very careful on that. But there are a lot of resources online, blogs from attorneys. There's a lot of literature out there, books. So I'd say, look around online for the specific issue, and you could probably find like a scholarly article on it. I would do that versus seeing, what kind of AI is put together from what they've pulled from various different websites that may or may not be credible. But if it's an attorney that practices in the scope and they have a blog on it, there's a ton of I know defense attorneys that have blogs and they touch on a lot of intricate issues. So I would look at that. There's a really good one that I've come across. I believe it's called FMLA Insights for the FMLA. They touch on like every FMLA issue. I see that come across all the time. As far as they do like a newsletter and whatnot. And actually they're constantly updating it with various issues that are coming up, especially with the remote stuff and whatnot. But yeah, I would do your own research, not AI research, and make sure it's coming from an attorney that practices in that scope. And you'll be surprised what you can find in there. There's a lot of literature.
Right, right. Um, can you break down, the classification differences, and I don't know if you've run into this, somebody that was treated as a contractor as compared should have been treated as an employee, and why there's that important distinction when it comes to hiring someone.
Right, right. That's a big issue. I don't do a ton of wage and hour, like I was saying, but this is something I am familiar with. There is actually a checklist on the IRS website that will have W-2 versus 1099, and it distinguishes based on the amount of control you have over the employee. One of them will be one of the columns will say the employee has a uniform, the employee has a set schedule, they can't come and go as they please, and that leans more toward them being an employee versus 1099 contractor who has more freedom to come and go as they please. An example of a 1099 contractor we're all familiar with, like a Lyft or Uber driver, right? They turn off on and off whenever they want. Yeah, there are some rules and regulations they have to follow, but they're their own business essentially. But it's not a hard and fast test.
Right.
It's a little gray. So that is something that if you're employing contractors, I would, if I was advising an employer, I would err toward having employees versus contractors unless you had specific advice from a defense attorney, because it can get a little tricky. Because then also what happens, you're not paying taxes, they're not paying their taxes off the top, right? So that runs into some issues there. And then on top of that, There could be they could be misclassified and working over 40 hours in a week when they should have got overtime, where a contractor may not be entitled to that, but a misclassified employee would be. So yeah, if you're going to employ contractors, I would be careful with that. And I would seek counsel, and I would err toward calling them employees versus contractors when in doubt, to be safe.
Right, right. Um, what are some of the red flags that you've seen when it comes to employers terminating people?
Right. I think timing between either a complaint about discrimination or sexual harassment and a termination is a red flag that I look for on my end. Timing between a request for medical leave or maternity leave or a request for accommodations and a termination, that's what gets the attention of the folks sitting in my seat as the employee's attorney. So that timing is big. When you just see kind of a totally bogus reason for termination come within a close proximity to one of those events, that catches attention, right? So what I see as hurdles on my end is when the employer has well documented concerns over a period of time. They're not rushing to get rid of this person, and then they have an objective reason for termination, not just some subjective, oh, your performance was lacking. No, like you had this goal, the same goal as everybody else, and you fell this far short. This is why you were let go. That stuff is tough to beat from my end as the employee's attorney. But when we have just a vague reason for termination and it's in a close proximity to those events that I just mentioned, medical leave, pregnancy, complaint of harassment, etc., then we typically have something to work with and have a good case to pursue.
Yeah. Now the you're talking about, like the Family Medical Leave Act and stuff like that. That really doesn't come in until somebody's got 50 employees, right? So
Correct.
the
But
smaller businesses don't necessarily have to provide that. That's up to them, but they could still get in trouble with these other things that you're talking about,
right.
proximity.
So yeah, I would still say the ADA could apply to a medical
Right.
situation for an employee or employer that has 15 or more employees. So while an employer does not have to grant 12 weeks of leave to an employee if the employer has less than 50 employees, they still would need to look at that ADA standard. Is it a reasonable accommodation or not? So, for example, if I ask my employer for a week of time off for medical issues and the employer has 17 employees, that's probably going to be reasonable under the ADA. It varies based on what state you're in, what the case law is in that federal court, district, or circuit. Right. But generally speaking, yeah, if you ask for a few days off, that's going to be considered reasonable. You ask to go to a doctor's appointment, every other week for a medical condition, that's probably going to be reasonable. Now, if you're asking for 4 months off, probably not going to be considered a reasonable accommodation under the ADA. So it goes back to that reasonable standard. And I wouldn't, yeah. So I think the short answer to your question, I wouldn't just dismiss medical leave options for employees just because you're not FMLA qualified as an employer. There are some protections under the ADA for employees.
No, is as the employer, I mean, it would create a hardship for me if someone were to be out for a month.
Right.
Because, because we're small, oh, I got this person doing it. That position is then open. Is that something that, from my side being a small employer, is that something that's defensible at that point to say, hey, I wasn't able to do that because I needed somebody in this position. I couldn't go that long. I offered, whatever, a week I could do or whatever. They didn't have the vacation. They already burned through their vacation. There wasn't anything left.
Right.
how does that work? And as the employer, is there an easy way to defend this or not?
Right. They're super fact specific, like case by case situations where, if the case went all the way into a lawsuit and the court made a ruling, the court would get very tedious into the facts. How many employees you have, how many people do that job. If you were required to hire someone to complete those duties and no one else could, different story. They would also look at, okay, this person asked for time off, did you offer them maybe to do it remotely? There's an interactive process that's required under the ADA where if you can't accommodate it as an employer, you have to give them an alternative possibly, and go through that process. So yeah, for an employer to protect themselves, I think they should engage in that interactive process as the ADA requires. And more they do that and provide alternatives or options, the better. Now, I would say if someone's just asking for straight up time off, it depends if they have a definitive return to work date or not. Now, if I'm evaluating a case on my end and someone has a definitive return to work date and they're asking for a couple weeks, even a few weeks, I feel like I may have something to work with there if that's not accommodated, especially if the employer didn't go over any alternatives with them. Now, if someone's just open-ended saying, I need time off and I'm going to be reevaluated in a few weeks and I don't know when I'm going to return, that's a little different. So if an employer follows up with the employee and says, hey, you're asking for time, but do you have a return to work date? And the employee says no, that makes me feel a little worse about the case from my end. So those are things I guess to answer your question about what an employer can do, see if there's a definitive return to work date, offer perhaps remote work as an accommodation if someone's asking for extended time off, and really engage in that back and forth. And the more you can, look like you were attempting to work something out, I think the better it will look for the court,
Right, right. Sounds like this is a pretty slippery slope that we all have to be careful on.
Right, right. The ADA is probably one of the most highly litigated areas of employment law, just because it's so gray and it's so case by case. And I guess I'm mentioning like how a court will rule. You obviously, both employees and employers want to avoid that,
Yeah,
right? And there's something called the Equal Employment Opportunity Commission, the EEOC, which is a step between um, where a termination occurring and a lawsuit. You have to go through that process and get what's called a right to sue letter if you want to bring a claim under the ADA. Some states will have equivalent laws where they'll have state agencies similar to the EEOC that you can go through. But yeah, generally speaking, if you want to bring a claim under one of the federal anti-discrimination statutes, ADA, Title VII, the Age Discrimination Act, you have to go through the EEOC before a lawsuit. A lot of cases settle in that EEOC process. So yeah, I think the EEOC website would be a good one for employers to look at as far as doing research and seeing, what laws apply to what size employers and responsibilities they have. The EEOC actually has some really good handbooks and whatnot on their website.
right.
I believe they call it an enforcement guideline or whatnot. So yeah, you can. I should have mentioned that earlier. That's a good tool for both employees and employers alike.
Great. So, Gary, what have I not asked you that you wish I had?
I think we covered a really good, really pretty wide scope there, going from policies to FMLA, ADA. I can't think of anything off the top of my head, honestly. I'm sure someone will come to me right when we
Right,
get off.
right.
And
Of
yeah,
course, of
I think
course.
we've covered a really good amount. And yeah, I mean, I think at the end of the day, just be fair. I mean, the employment laws are not rocket science, really. Maybe aside from the wage and hour gets a little complicated with exceptions and whatnot. But as far as laws surrounding terminations, it's not really rocket science. Be fair, be educated. One thing that I was going to say, as far as one thing, if I've never been on the employer side, but I go up against them enough to know a lot of employers have employment practices liability insurance.
Right.
Especially even small employers can have that. And that's something that it's not super expensive, my understanding. So that would be something to look into. So yeah, that would be the last point that I think if I was ever advising an employer, just from going up against them enough, I know that EPLI insurance, employment practice liability, is available to them, and yeah, that's probably something that to look into.
So, Gary, if people want to talk to you, how can they reach out to you? Where can they find you?
Sure, sure. So our firm's website is martocciofirm.com, Martocciofirm.com. So yeah, I represent employees exclusively, and do a various range of practices, covering a lot of those practice areas that we've discussed here on this podcast. But yeah, happy to evaluate a case. I'm licensed in 9 states. All of our locations are available on our website, and we also have some good articles on there as well, that both employees and employers can get some, I guess, research from. So yes, that the website has all the contact information. That's the best way to get a hold of us.
Okay, great, great. Really appreciate your time today in our conversation.
Thanks, Gary.
All
Appreciate
right,
it.
thank you. And this
Thanks.
week, my guest was Gary Martoccio, and he is the founder of Martoccio Firm. And I'll see you guys next week.